seated. Call now cause number PD 001823, Continental Heritage Insurance Company, Agent Pat Kinnard, DBA Pat Kinnard Bail Bonds versus State of Texas.
Good morning, and may it please the court. My name is Niles Illick, and I represent the appellate. The case we present today has three questions that I think we ask this court to answer. The first is whether criminal bond forfeiture cases are in fact criminal cases. The second asks if criminal bond forfeiture cases are in fact criminal cases, do civil filing fees apply? And finally, if these are criminal cases and if civil filing fees do not apply, then is Article 103.008 an appropriate remedy to recover fees that should have never been paid in the first place? Now, David and I have been arguing this case, I think, for 3 years now, and we come to this court thankful for getting us in quickly and respectfully asking for resolution. Turning to our first question, the question of whether or not criminal bond forfeiture cases are in fact criminal cases. In many respects, for me, this is the easiest question, and it's the easiest question because of this court's precedent in Dees and Safety National, where this court said unequivocally that these are criminal cases with final jurisdiction resting in this court. And in fact, we are here today in this court instead of being across the hall. Now, the state has asked you to view this as criminal in name only, and I think that's a mistake. This is a criminal case. In my mind, we only have two types of cases here. We have criminal cases and civil cases. This is a criminal case. Now, of course, the problem and the challenge is that this is a criminal case governed in some respects by the rules of civil procedure. And we know that from Article 2210 of the Texas Code of Criminal Procedure. And it is in large part the language from 2210 that brings us to the court today. For my client, the language at the end of 2210 that discusses the implication and the use of the rules of civil procedure means exactly what it says, and that is that we use the rules of civil procedure to fill gaps where the Code of Criminal Procedure doesn't have an answer. Things like execution, things that we're commonly aware of and we do in civil courts all the time, but which are not frequently encountered in criminal courts. For the state, however, Article 2210 says not only the rules of civil procedure, but the statutes. And this distinction matters because it's the rules of civil, it's the statutes, not the rules, that bring in the civil filing fees. And I think the best way to start here is really to look at the plain language, and that's where this court starts with every good opinion. And when we look at 2210, I'm not going to read the whole thing, but the operative language is that the proceedings had therein shall be governed by the same rules governing other suits. So 2210 says rules, it doesn't say statutes, and thus we take the legislature at its word that it's the rules of civil procedure that are used when they need to be in criminal bond forfeiture cases. But more than that, I think we can look at the civil filing fees statutes. Now, it's important, and I'll get to why in just a minute, but the civil filing fee statutes were amended in 2021. When this case started in 2019, there were all these individual statutes, and now we have a consolidated fee schedule. It changed in 2021. But whether we look at the cases from 2019, or the statutes from 2019, or the current statute from 2021, the operative language is the same. And
I'm just curious, when you got to that fork in the road where you were going to appeal the intermediate appellate court, it's just a toss of the coin. Do we go to the Supreme Court or the Court of Criminal Appeals, or were you?
It was absolutely clear to me. So this case was oddly docketed as a civil case in the Fifth Court of Appeals. Okay. And it was an error to docket it as a civil case.
Was that recognized at that level?
They did. Justice Schenck wrote in his opinion in the Fifth Court of Appeals that this is absolutely a criminal case. Okay. And I have no question in my mind that this is a criminal case. And I think this court's opinion in Dees And this court's opinion in Safety National say that expressly and explicitly, that this is a criminal case.
So, Mr. Illick, but you do agree that it is governed by the rules of civil procedure?
It's governed by, yeah, it's governed in part, Judge Keel, by the rules of civil procedure.
Only in part?
Well, there are parts of Article 22 that say, here's what must be in a citation for a bond forfeiture. And there are rules in civil procedure that say, here's what should be in a citation. And I think in a situation where you have the criminal statute saying this is what needs to be in the citation, and you have something over here, to the degree there's a conflict, I would say we would go with Chapter 22 of the Code of Criminal Procedure. But I have no problem incorporating all of the civil rules. What I have a concern about is if we incorporate the civil statutes.
What about Rule 145A, which this,
Rule 145A of the Texas Rules of Civil Procedure,
Yes,
which
sir.
counsel
Yes.
relies on thoroughly in his
right,
brief.
what do you
Sure.
say about that?
Sure, 145A of the Texas Rules of Civil Procedure defines what a court cost is in civil cases. And certainly, no one is going to dispute that that would include a filing fee. But the real question here is not whether or not the definition of a court cost would include a filing fee, Judge Keel. The real question here is whether or not the filing fees that have been assessed against my client applied. So in other words, if we have a criminal case, which I posit this is absolutely a criminal case, and then we have civil statutes that say the civil filing fees are assessed upon the filing of a civil suit, my answer is when you put those two together, you can't have, we never have a civil suit here because this is a criminal case, right? So if you never have a criminal case, you should never have civil filing fees assessed. And so I'm not, and forgive me for getting you a long answer to a short question. 145 defines what the filing fees, what the costs of court are. We don't dispute that a filing fee would be a cost of court. We dispute that these filing fees applied. And this is really where Ranger got it wrong. And this is where we're coming to the court asking the court to correct Ranger. And that is when Ranger looked at it, it said, okay, we've got a cost of court. Fine. The cost of court includes the filing fees. Fine. D's says you pay, you as the surety, pay the costs of court. Therefore, you have to pay the filing fee. What Ranger didn't do, and I think what the state misses when it relies on 145A, is the analysis to ask whether or not the civil filing fees actually belong in the costs of court. So we're stepping back all the way to the beginning and saying we are happy to pay what we owe. We will pay every bit of what we owe. My client has no problem, no objection to paying costs of court. What he objects to is paying things that should have never been assessed against him in the first place. So 145A says, yes, filing fees are assessed as costs of court, but it doesn't say, it doesn't provide any indication of whether or not these filing fees should have been included in the first instance. Does that answer your question, Justice Keel?
It seems like you want us to parse out what are court costs versus what's a filing fee. And looking at your brief, it seems like you really delve into that in some depth.
I think that's one approach to it. I think this court is pretty good at, it's had Judge Hervey's written a lot of opinions about what are court costs and what are fees, and it's, Judge Janie Maselli in Houston has written on this, and we can talk about that. But I think the key here is that the real issue, that the core of this is the question of whether or not civil filing fees belong in the costs of court. That's the real question. Do these civil filing fees belong in the costs of court? If they belong in the costs of court, then we owe them and we will pay them. But if they don't belong in the cost of court, then we shouldn't have to pay them. They shouldn't be assessed against us. So the debate is, in my mind, whether or not the civil filing fees apply in a criminal bond forfeiture case. And when I was talking earlier about the plain language, I think it is the best place to begin to make that assessment. We look at 2210 that says it's the rules, not the statutes. We know that the Civil filing fees come from the statutes, not from the rules. Second, we look at the civil filing fee statutes, both those that existed in 2019 and those that exist now in the consolidated fee statute. They all say that they are assessed upon the filing of a civil suit. We do not have a civil suit here, number one, because it is and always remains a criminal case. But we can go further than that, and you can look to Articles 2201 and 2202 of the Code of Criminal Procedure. And what those say is that a bond forfeiture proceeding begins with a judicial declaration, not a petition. Texas Rules of Civil Procedure, Rule 22, says that a civil proceeding begins with a petition. Now, David and the state would like you to believe that a judicial declaration equals a petition, but a judicial declaration comes from the court. The court writes this judicial declaration that says if you don't show cause why your client didn't show up, we're going to assess this against you. A petition comes from a party saying, court, this party did this to me and I'm asking you for this remedy. These are fundamentally different things. One comes from the court, one comes from the parties. And the reason that's important is it goes to whether or not we have a civil suit, right? We do not have a civil suit, number one, because this is a criminal case, it always remains a criminal case. Number two, because we never have a petition. Rule 22 of the Texas Rules of Civil Procedure says that civil cases begin with a petition. We do not have a petition ever in this case. What we have is we begin with a judicial declaration. That judicial declaration is a statement from the court, and it would be a very odd position to begin a civil suit with a statement from the court. That just isn't how a civil case would proceed. Then we can look at Articles 2201 and 2202. We can also look at the statute of limitations in 2218, compare it with the language in Texas Civil Practices and Remedies Code 16003. And what all of that says is that the plain language says that we never have a civil suit here. If we never have a civil suit, we can never get to civil filing fees, right? The consolidated fee schedule and the fees that existed in 2019 say those fees go in only upon the filing of or commencement of a civil suit. And here, we never have a civil suit. Without a civil suit, you can't get to these. Now,
Counsel, let me ask you a question based on what you're saying. And bear with me, my background's criminal.
Of course.
I have very little civil background.
It's a strange case to be here.
In criminal cases, there is no such thing as a filing fee, correct?
Yes, correct.
Prosecutors don't have to pay a filing fee before they charge somebody.
Right.
Okay. So what is the purpose in civil cases? What is the basis for having a filing fee?
Sure, it's simply a revenue generating fee, almost like any other tax. So I've set them out in there. It pays for the law library. It pays for your salaries because there's a judicial salary fee. I'm sorry to be arguing against your salary here. That's a little bit of an awkward position for me to be in, but it pays for like 19 different things. And it pays for, it's just a tax that pays for all those things.
Okay. And a criminal filing fee could do the same thing as that, but as far as separating criminal cases from civil, is it possible that part of the reasoning for civil filing fees is to keep frivolous lawsuits from being filed?
I have never, frankly, I've never thought about that, but it seems like a very good approach that would keep frivolous lawsuits from being filed. But it's just something I don't know.
All right. Go ahead.
Of course, if the legislature intended to exclude these, they could have specifically said so.
And Judge Hervey, I think that's one of the strongest points here, and I think they did. I think the legislature was really clear about not wanting these to apply in this case. They changed from all these individual statutes in 2019, they had all these individual fee statutes. All right. 2021, the legislature convenes. They change it from all these individual statutes to a consolidated fee schedule. Now, when you look at that consolidated fee schedule, even the title says that they only apply upon the filing of a civil suit. And it says in the statute itself, of course, that it only applies upon the filing of a civil suit. So I think the legislature has been very clear that these fees only apply in instances where there is a civil suit. Here, for reasons I've identified, because number one, it's criminal, remains criminal, and number two, there's no petition. I see that I've run out of time, Judge Harvey. Do you mind if I finish answering your question? There is never a civil suit, and because there's never a civil suit, we believe that we're operating under the plain language as the legislature gave it to us, even after amending it in 2021. If there are no further questions, I know this is a complicated topic, I will yield the podium.
Thank you, counsel.
May it please the court. I'm David Villafuerte, representing the state from Dallas County District Attorney's Office. First thing I would like to mention, I'd like to make this simpler for everyone involved, so it doesn't get to the point where we're going back into history. But civil costs include fees, filing or otherwise, and that's defined by the civil rules. And these cases already held that civil costs apply in bond forfeiture cases, and I believe that should end the debate. Now, the civil rules apply because Article 2210 says that they do, and the costs are already mandated by Chapter 22, and they're mandated through several provisions there. And even the judgment that came down from the Fifth Court of Appeals stated each party would bear its own costs. It didn't have a separate line saying, you know, you're going to bear your costs, somebody else is going to bear the fees, because these judgments just don't do that. You know, they mention costs. I mean, from People's Court up to the Supreme Court, the prevailing party, if they're ordered costs, they get their filing fees back, because sometimes the only thing a party can prove are their filing fees. And that's just the way the civil cases are handled. And that's at the heart of this matter, because the petitioner is attempting to carve out an exception that doesn't exist, or to restate something that doesn't have to be restated, because they don't want to pay their fair share of costs. Bond forfeiture cases are criminal cases, okay, but in name only. Because if you go back to the Safety National opinion, it states in there, as they looked at the history, the civil statutes that were in effect in 1879 did not restrict their application to civil cases only. And that line, that may not have seemed important then, fits perfectly with the bond forfeiture case, because the bond forfeiture case, I'm not saying is transformed into a civil matter, but it behaves as a civil matter. I mean, first of all, it's governed by the civil rules to begin with. Costs are already mandated. But in there, you have, it begins with a citation and petition. Okay, the judgment not signed and the citation are the state's petition. And that's from the Blue case, Blue v. State, Nichols v. State, Pollux v. State, and Bonds v. State. It clearly states the citation and the judgment not cite are the state's petition. And they're filed in every case. They may not be filed the way the petitioner wants them to be filed, with somebody going up to the clerk getting them stamped, but they are definitely filed. But with that, an answer has to be provided by the surety. If an answer is not provided, a default judgment can be taken. That doesn't happen in criminal cases. If there's not a default judgment, that answer has to be processed. It has to be docketed. Then you can also have discovery, mediation, summary judgments. If there is a judgment, then you can have executions. Then after that, those cases have to be indexed and processed. They behave exactly as a civil case behaves, which is why these cases stated that the civil costs are applicable, and those civil costs include civil filing fees. And that's just what the rule says. Ranger examined Dees and it examined Safety National, and it did not conflict because Dees held that the civil costs apply. And the reason why the cases are civil proceedings governed by Article 2210 is because they involve money. Nobody's going to jail. Yes, they're criminal cases in name only, with all of the behaviors of a civil case, which mean all of the costs that a civil case incurs. So Can somebody look at it and say, okay, we're going to make a new rule, we're going to discard one of the 822 civil rules and apply them to a bond forfeiture case? Because what do you do in the case you do have a deposition, you do have a mediation? Who's going to pay for the court reporter? There is a bailiff and a judge in every one of these cases. They occur in courtrooms. Each courtroom has security. You know, all of these things apply. And because they all apply, D says you must pay the civil costs. Now, what Ranger did not do, Ranger could have bolstered its own opinion by going in and saying, hey, we're further going to explore the civil rules and we're going to define what costs are. But they didn't have to do that because it already existed. It just had not been briefed, and I missed it at the Fifth Court of Appeals, and apparently they did as well, and petitioner missed it in his briefs. No one had read 145A, which defines the costs. You know, they rely heavily on the concurrence in Safety National, where it said the civil rules should apply, but they didn't account for Rule 145A. Because 145A...
Are the costs the same for every case, or do they vary based on the nature of the case?
The costs vary
question.
based on how the case is served. If it's personally served, if there's a citation, or if it's waived. That varies, but the other costs that are the civil filing fees are the same for each of the bond forfeiture cases.
So what are we talking total here?
With the new statutes in effect, approximately $458. And that would include each fee that could be assessed. You know, we're talking about personal service, we're talking about the citation being printed, along with the new consolidation of fees.
Is it always the losing party that pays these costs?
Yes,
So if the state lost its bond forfeiture case, the state would pay the costs?
no, the state does not pay filing fees to itself.
Okay.
And that's why these become, that's why they're not paid up front. These costs are paid at the end of the case. So basically, what you alluded to earlier, what happens when you pay these costs up front, you know, or why is the cost paid up front? In the bond forfeiture case, the costs are just simply put at the end of the case.
Whereas in a civil suit, they're paid up front,
Correct.
the filing fee.
Yes, sir. Yes, Your Honor.
And you said your civil filing fee is $458 roughly, the filing fees?
Your Honor, that would be the total of all of the fees.
Okay. Now, is the 458 or the filing fees the same for very complex civil cases as they are for fairly simple ones?
They are now with the consolidation of the fees.
So they're getting enough money on each one to cover the very, very expensive cases that cost the state thousands and thousands of dollars to try, along with the others. So it's kind of, one certain amount covers all that.
And that would seem to be the theory, Your Honor.
And in bond forfeiture cases, they're all almost always going to be right down at the very simplest of cases.
Yes, Your Honor. The majority of these cases, we'll say close to 99% of them are settled in court without a trial.
Okay, so if the state laws that set the filing fees for civil cases at 458 are done that to cover all civil cases, I'm having a hard time with putting bond forfeiture cases right in there with them when they're always going to be very simple, and a lot of them are going to be just agreed. Most of them will be agreed.
Yes, Your Honor, I understand that question. Unfortunately, with the changing of the statute, it no longer parses out which fees are applicable. So before, when you had all those separate fees, somebody could possibly exclude a mediation fee if mediation wasn't included. However, that goes against the entire fee structure, which says we charge everybody, and the law already supports that because everyone has access to the law library. You don't have to be the one to use the law library for us to charge the $15. You know, now that is no longer in effect as they've consolidated everything. But those costs that you speak of are specifically mandated against the surety in Chapter 22. And it mentions nothing about, if the losing party is a state, this is how the state would recover its own costs from itself. And that just seems to be something that it cannot be done if the state owes itself $10. Is the state going to go to the treasurer, cut itself a check for $10 to pay itself $10? And that just does not happen. But that's why presumably the costs are that way, Your Honor.
But if the state loses, then the surety doesn't have to pay, correct?
Correct. It's if the surety doesn't, the costs are mandated. And we talk about intent, the overall intent that nobody speaks of is if you get the defendant to court, you don't pay anything. But if you don't get the defendant to court, you pay the cost, you pay the judgment, or you pay the rearrest fees, you pay the cost to transport the defendant back. That's the overall intent. But what these cases have become, at least in Dallas County, is do we have a forfeiture? And if we have a forfeiture, what ways can we avoid having to pay any of the costs? Well, we have to pay the cost. Well, can we parse out some of these costs? Well, unless this court is willing to say, we're going to comment on this civil rule, we're going to comment on Article 2210, we're going to reverse these, because that's what would have to happen. It's not so much the Ranger case that's the problem. What the petitioner seeks is a redefinition of something that doesn't have to be redefined. The costs are already defined, whether we like it or not. The clerk assessed the costs, and they used the civil rules.
So the costs are the costs, but it's my understanding that some counties will negotiate on bond forfeiture, so that's a separate matter, correct?
I understand, yes, Your Honor. They may not be able to negotiate on the cost.
Right.
They can negotiate on the judgment amount.
Right, okay.
But the costs remain the costs. Civil filing fees have been civil costs long before this case has ever been filed. And regardless of whatever is decided, those will still be what they are. Now, there may be some exception written saying we're not going to apply this rule. Well, if you're not going to apply this rule, then what other rules do we need to lay out to say, okay, we don't like this one either because this one costs money, this one we can't explain. Now we need to make an alteration to Article 2210 that says the civil rules apply except for the ones that involve the cost of court, and not only the entire rule, we're talking about a sub-portion of one rule. So that's a lot of civil rules to run through. And the district clerk and county clerks are the ones who are responsible for assessing the fees, and they assess the fees by going to the civil rules and the civil statutes, which are what give the authorization for them. And that comes, once again, through Article 2210, and Dees has already said what the costs were, and Chapter 22 has already mandated the costs. And I think that takes us exactly where we need to be. We're back to square one, which is the correct square. And as we talk about these being costs, we get into the plain language. Everybody likes the plain language when it feels it supports them. But when not, okay, plain language, but we got a couple of exceptions. Article 103.008, by its plain language, serves to correct costs and not fees. Clearly, and further we'll argue, it serves to correct costs that are assessed via the Code of Criminal Procedure and not costs that are assessed through the civil rules that are authorized by civil statutes that are applied to bond forfeiture cases through Article 2210. It's just not there. Somebody would have to rule that civil costs are, by the rule, criminal costs. And as soon as you say that, I think we're done because Dees already says the civil costs apply. You don't have to get any further. And the only reason why we got to this point is because Kubosh had said, not in their holding, but they mentioned that this was one of the methods, not the exclusive method, but they never construed the article. Because they say a surety is a defendant, but not for all purposes. If you go back to the appellate statutes, I can understand why there's an exception for a surety to be considered a defendant when it comes to an appeal, because 4402 and 4442 state only the defendant has a right to an appeal. So if there's not a legal exception made, surety has no right to appeal a bond forfeiture case. But that's not the same case for the correction of costs. There are at a minimum 3 ways to challenge costs. If you count the nunc pro tunc, there's a 4th way. So why would the legislature see fit to say we're going to add a 5th way under the criminal rules and we're going to extend the time from 30 days to a year to challenge these costs? And somebody would say, well, it doesn't affect the finality of the judgment because it's only the cost. But we know good and well the case is not disposed of. The case, the clerk still has to deal with that case as this case is on appeal. When did this person forfeit? A long time ago. And we're still arguing about the costs. So if the costs are returned, Is somebody gonna track down the defendant? Hey, you paid these costs back in 2017, we got it back, here's your money. No, so it offers no protection to the defendant. And because these costs are political in nature, then they affect everybody, not just the parties involved here. They need statewide representation, which means the legislature needs to be the ones who say, we're going to come out and we're going to set a rule to mandate it. Because the legislatures are the one who wrote 2210. They're the ones who mandated costs in Chapter 22. And they're the best one who answers to the taxpayers, because the taxpayers are the ones who get to hold the bill if someone says, hey, they don't have to pay these costs. Why would the legislature set up the bondsman so that the taxpayers would have to subsidize their business? The costs of court, whether they're high or whether they're low, are part of the business. And you avoid the costs of court if you get the defendant to court, as you've agreed. Nobody's being forced to post these bonds. This is a for-profit business. Yes, the business does help the state because it has someone else tracking down the defendant. But you get the person to court, you don't have to deal with the costs. There's no question on the costs. But if you don't, there's several areas in Chapter 22 that says you must pay those costs. And going all the way back to the Dees case, it's the civil costs that you have to pay. And we can argue, hey, we don't like the civil costs. Maybe nobody does. But it's not about a defendant having to pay these costs, because if the costs, these filing fees are high, if a defendant, a criminal defendant, the accused, which is the plain language of the defendant, can't afford the cost, there is a mechanism so the defendant doesn't have to pay them. That doesn't exist for the surety, because the surety is running the business. If he says he's indigent, he can't have a license. So that becomes part of why these costs have to be paid. They have to be paid because they are a failure to follow through on the agreement to get the defendant to court on time.
And counsel, you do understand my point that if we rule in your favor, we're telling bonding companies all over the state of Texas that they need to help subsidize the court cost on all these complex litigation cases, when all of their cases are so simple. They're 30-minute cases and they're done, usually.
Yeah, I understand, Your Honor, and that is the nature of the cost of court. The cost of court exists to support the entire court system, and not just one single case. Because if it's done that way, it would be fair if you could say you're going to bear your own costs.
But I understand that, but what we're talking about here is not just all costs, but the civil filing fees that the bondsman, you're asking that bondsmen everywhere have to pay civil filing fees, and they came up with it $458 to kind of round out everybody, and that would include all the super complex cases.
Yeah, I understand, Your Honor.
Okay.
Understand, and that's just the nature of the cost because they're defined that way.
And I'm making an equity argument. It's just.
Yeah. No, I do understand that. In bond forfeiture law, though, it's the legal arguments that rule and not equities, or not cases of equity. But I do understand.
Okay.
I do understand that. And that has been the case since 2010. They have paid those costs. Now, what individual clerks throughout the state charge, I would have no idea. But I know in the two counties where I've worked, Denton County and Dallas County, all of the fees are charged. And further, the big picture is if you get the person to court, you don't pay. If you don't, then you incur all of the costs. And just speaking back on Ranger being good law, Ranger examined these, Ranger examined Safety National. It looked at the exceptions, because we're not talking about civil appellate fees, we're talking about filing fees in trial, at the trial court level. And it stated, yes, there's not a conflict, and there should never have been a distinction between the two, and that's where the confusion comes from. And in closing, I would like to say that cost of court is a set of costs, other than just a phrase we use all the time, that includes filing fees. And the civil rules govern the bond forfeiture cases. And Ranger should be upheld, as is clear. The petitioner doesn't seek to overturn Ranger as much as it seeks a redefinition of what civil costs are. No distinction needed to be made, as Dee's already held. They applied. Dee's doesn't need to be overturned, and they're not asking this court to overturn Dee's, and they're not asking the court to alter 2210 nor comment on a civil rule. They just don't want to pay their fair share, and they have their avenue, which is go to the legislature who set them to begin with. This court should reverse the holding of the Fifth Court of Appeals that Article 103.008 can be utilized by a bondsman in a bond forfeiture case. Clearly, it was never intended, and it had never been done before prior to this case, but for the one line in Kuwash. Because if it's not reversed, it creates a two-tier system to challenge costs. You can challenge costs through the civil means, motion to retax costs, motion for new trial, and declaratory judgment. But if those don't pan out on the civil side, then you have up to a year to file the same challenge on the criminal side. And they could have never meant for this two-tier system to have been created.
Can I ask you, you're challenging his use of 103.008, almost like a cross point of error, but you didn't file a petition with a cross point of error, right?
No, I did not, Your Honor.
So really, should we even reach that issue?
Your Honor, I see I'm out of time. I ask permission to answer that question.
Yes.
I understand that in the case on appeal of the Fifth Court of Appeals and what's been granted here, that everything in the holding was still up for argument and up for decision. With that, thank you very much.
Thank you, counsel.
If there's one thing that I would like this court to leave this argument with today, it's this. We agreed to pay our cost, and I'm a little insulted by the idea that we are trying to shirk any responsibility that we have. We will pay what we owe, and we agree with these that we owe costs of court. We agree with that. What we don't agree, and this is the real crux of the issue, is whether or not civil filing fees should be included in the costs of court. That's the dispute. Do they belong in the costs of court? If they belong in the costs of court, we owe them and we have to pay them. The question is, do they belong? Our answer is they do not belong. And they do not belong because what we have here is a criminal case. Counsel conceded it's a criminal case. It's a criminal case. It remains a criminal case. The plain language of the statute from 2019, as it was revised in 2021, and as it exists now, says these are only assessed upon the filing of a civil suit. We never get to a civil suit in this case. There is no civil suit in this case. Because we're criminal, it's a criminal case. And because it's a criminal case, we don't get to a civil suit, and therefore these fees should never apply. I paid my taxes this year on April 14th, and as I was listening to counsel, I was listening and thinking about it. I paid it to the penny. I paid every bit of the money that I owed. I didn't pay any more. And if I had looked at my taxes and I'd been assessed some corporate tax fee, I would have said, hold on, I will pay what I owe over here. This is what I owe. Let's just make up a number, $8. But I don't owe this additional money that goes on a corporation. That's not part of who I am as an individual under a W-2. I'm not shirking my responsibility to you and to this government by saying I don't owe this corporate tax. What I'm doing is paying what I owe. And that's exactly what my client as an individual businessman here is trying to do. Now, it's easy.
But that's the same kind of argument people say when they don't have children and have to pay for schools.
I'm not sure I understand the question, Judge Harvey.
I mean, if I'm an older person and I have no children, never have, and I'm assessed taxes in where I
Property
live,
taxes, right.
and I'm paying for schools, when I don't have any kids, I guess I could have that same argument. I shouldn't have to pay that
Well,
because I don't have kids in school.
I don't think it's the same argument, and here's why. I don't think it's the same argument because we agree as a society that those taxes apply whether or not you have children. They apply to everyone that owns property. That's our deal as a society. We've agreed on that through the legislature. Here,
Well,
go ahead.
couldn't we say that the legislature as a society has decided that everybody has to pay certain court costs or fees?
Sure, and that's what I want us to answer, right? And the answer to me is that they've said you do pay those in every single civil case, okay? But you don't pay them in a criminal case. You do not pay civil costs in a criminal case. And
So you're not recognizing the judgment nisi or the citation as a document to get you into forfeiture land? A civil case?
it does not transform or ever become a civil case. And I get that from Dees and Safety National that say expressly and explicitly this is a criminal case. If this is a civil case, I lose. I'm in the wrong court and I lose. This has to be a criminal case in order for me to prevail. And for me, it starts as a criminal case, it maintains as a criminal case, and it ends as a criminal case. And we get that from Safety National and from Dees. In the end, I think the rule that we're asking this court to come up with is this, that a bond forfeiture case is a criminal case. It is always a criminal case. It is governed in part by the rules of civil procedure. The rules of civil procedure do not assess civil filing fees. That comes from the civil statutes. We are responsible for paying our court costs, and we will pay them, but that those court costs do not include civil filing fees. Those are things that come only upon the filing of a civil case. And in this case, we simply never have a civil case, and the fees should not apply. With that, we thank the court for their time this morning, and if there are no further questions.
Thank you, counsel.
Thank
The
you.
case is submitted.